of the president, of the president-elect?
We don't know who sent the taskings. If the taskings were changed into what went into these intelligence reports, but we're going to try to find that out.
Chairman, was the president personally involved?
Put out this information today. Did the Justice Department give you the okay to talk about this?
Justice Department doesn't have anything to do with this.
So how
this is information. This is information that was brought to me that I thought the president needed to know about incidental collection, where the president himself and others in the Trump transition team were clearly put into intelligence reports that ended up at this White House and across a whole bunch of other agencies. And I thought it was important for the president to know this. That's why I briefed the speaker this morning, and I came down here as soon as I could. What's happening. At our open hearing on Monday, I encouraged anyone who has information about relative topics, including surveillance on President-elect Trump or his transition team, to come forward and speak to the House Intelligence Committee. I also said that while there was not a physical wiretap of Trump Tower, I was concerned that other surveillance activities were used against President Trump and his associates. So first, I recently confirmed that on numerous occasions, the intelligence community incidentally collected information about U.S. citizens involved in the Trump transition. Details about U.S. persons associated with the incoming administration, details with little or no apparent foreign intelligence value, were widely disseminated in intelligence community reporting. Third, I have confirmed that additional names of Trump transition team members were unmasked. And fourth and finally, I want to be clear, none of this surveillance was related to Russia or the investigation of Russian activities or of the Trump team. The House Intelligence Committee will thoroughly investigate surveillance and its subsequent dissemination to determine a few things here that I want to read off. Who was aware of it? Why it was not disclosed to Congress? Who requested and authorized the additional unmasking? Whether anyone directed the intelligence community to focus on Trump associates?
Operations and constitutionality of Section 702 of the Foreign Intelligence Surveillance Act, or FISA. In February 2016, the Judiciary Committee held a classified hearing that began our consideration of the reauthorization of the FISA Amendments Act, which was first signed into law in 2008 and reauthorized in 2012. Our hearing last year served as a good background and foundational update on the status of national security operations under the law. Much has happened since the law was last reauthorized, however, including the unauthorized disclosures of classified information by Edward Snowden in 2013 that spawned significant public debate on U.S. government surveillance. We also have many new members who have not yet had an opportunity to directly question experts regarding the statute's successes or areas where reform may be needed. Finally, we have very recent jurisprudence upholding the statute's constitutionality. Like congressional oversight, judicial oversight of this program is an integral safeguard, so exploring various courts' legal analysis concerning 702 will be beneficial for our own oversight as well. Congress enacted FISA in 1978 to establish statutory guidelines authorizing the use of electronic surveillance in the United States for foreign intelligence purposes. Following enactment, global communications infrastructure shifted from satellite to fiber optic wire, altering the manner in which domestic and foreign communications are transmitted. This technological shift had the adverse and unintended effect of requiring the government to obtain an individualized FISA court order to monitor foreign communications by non-U.S. persons. The government had to obtain probable cause to investigate a foreign national located overseas, an untenable proposition that served to extend rights under the U.S. Constitution extraterritorially and limit lawful U.S. intelligence activities. In 2008, the FISA Amendments Act corrected this anomaly by establishing procedures for the collection of foreign intelligence on targets located outside U.S. borders. At its core, Section 702 of the Act permits the Attorney General and the Director of National Intelligence to jointly authorize the targeting of non-U.S. persons reasonably believed to be located outside the United States. As an important safeguard, The Act prohibits the use of Section 702 to intentionally target a person inside the United States and forbids so-called reverse targeting using Section 702 to target a person outside this country if the true purpose of the acquisition is to target someone out inside the United States. Furthermore, the government may not acquire a communication to which all parties are known to be inside the U.S., and all Section 702 acquisitions must be conducted in a manner consistent with the Fourth Amendment to the Constitution of the United States. Section 702 also prohibits the intentional targeting of a U.S. person outside the United States. Instead, Sections 703 and 704 of the Act preserve Fourth Amendment protections for U.S. citizens by requiring the government to obtain an individualized order from the FISA court, known as the FISC, to acquire U.S. persons' communications while they are outside the United States. America's intelligence community has deemed Section 702 its most important tool in battling terrorism. However, it has also been criticized by some as an overly broad program that collects communications of U.S. citizens without sufficient legal process. Today's classified and public panels afford members an opportunity to examine Section 702 collection in greater detail and probe the aspects of this important collection with which they may be concerned.
Thank you, Mr. Chairman. Mr. Comey, Admiral Rogers, thank you for being here today and for your what appears to be attempts at being forthcoming with the committee. I also want to thank the chairman and the ranking member Schiff. This is a bipartisan effort. I think as you've looked to what this committee is undertaking, everyone wants answers, and everyone wants answers to all of the questions that are being asked, because this does go to such an important issue concerning our elections. Admiral Rogers, I'm going to begin with a question to you concerning the Foreign Intelligence Surveillance Act. Now, Admiral, as you know, that the Foreign Intelligence Surveillance Act provides the circumstances or the authority under which the intelligence community may collect or intercept the communication of a foreign person located outside of the United States, or, as Mr. Comey has indicated, a person who is covered under a FISA court order. With Mr. Rooney and Mr. Gowdy, you discussed the minimization procedures under the Foreign Intelligence Surveillance Act, and those minimization procedures are supposed to protect the privacy rights of U.S. citizens. Specifically, it's geared toward the communications of those who may be inadvertently or incidentally collected as a result of the intelligence community's lawful collection of communications of others. So, Mr. Rogers, is the intelligence community required to cease collection or the interception of communications if the result of the collection or interception includes the communications of an incoming U.S. administration official, the President-elect, or the President-elect's transition team?
It depends under what authority we're, as I said early on, there's a series of questions we go through. Is there criminal associated activity? Does the conversation deal about threats to U.S. persons, breaking of the law? So there's no simple yes or no. There's a series of processes.
Is there any provision of minimization that requires you to cease collection? Because that is my question. Are you, under any circumstances, required to cease collection if the collection results in the either inadvertent or incidental collection of an incoming U.S. administration official, the President-elect, or the President-elect's transition team?
Purely on the basis of exposure of, I want to make sure I understand the question.
Are you required to cease if you are undertaking lawful collection under the Foreign Intelligence Surveillance Act of a person or individual, either because they're a foreign person located outside the United States or the person that you're collecting against is the subject of a FISA court order? If incidental to that collection or inadvertently the collection results in the collection of communications of an incoming U.S. administration official, the President-elect, or the President-elect's transition team, are you required under the minimization procedures to cease collection?
Not automatically.
More powerful tools to use against foreign threats. Consistent with that goal, Section 2 of the Act has been used to monitor suspected terrorists overseas, to trace their networks, and to disrupt their plots. All of us in this room, I imagine, support that goal and those activities. We're here today because of the other things that Section 702 has been interpreted to allow. The government is not simply monitoring foreign terrorists and foreign suspects. Instead, it's scanning the content of almost all of the international communications that flow into and out of the United States, and is acquiring hundreds of millions of communications each year. We know from how the data is collected that it includes a massive amount of Americans' communications. But despite repeated requests by members of this committee, the government still has not managed to provide an estimate of how many Americans' communications are swept up. We also know that despite being required to minimize the retention and use of Americans' data, the government keeps that data for years and routinely searches it for information to use against Americans in ordinary criminal proceedings. According to the Privacy and Civil Liberties Oversight Board, the FBI searches the data when performing assessments, which are investigations that lack a factual predicate. That means the FBI is reading Americans' emails and listening to their phone calls without a factual basis to suspect wrongdoing, let alone a warrant. I don't believe this is what Congress had in mind when it passed Section 702. In writing the law, however, Congress did give significant discretion to the executive branch and the FISA court, trusting them to implement the statute in a manner consistent with its objective. So, for instance, Congress allowed the targeting of any foreigner overseas, trusting the government to focus its efforts on those who pose a threat to us. Congress also left it to the executive branch and the FISA court to come up with specific minimization rules. I don't mean to imply that this trust was misplaced. In fact, we've seen essentially no evidence of intentional misuse. But what we have seen is mission creep, so that a law designed to protect against foreign threats to the United States has become a major source of warrantless access to Americans' data and a tool for ordinary domestic law enforcement. This outcome is contrary not only to the original intent of FISA, but to Americans' expectations and their trust that Congress will protect their privacy and their freedoms. As it now stands, law-abiding citizens of this country and others are vulnerable. Their personal information sits in massive databases where it's subject to being hacked by the Russian or Chinese government, cyber criminals, or I suppose a 400-pound hacker sitting on his bed. American technology companies are facing the real threat that they'll be unable to do business with foreign companies and customers because of our government's collection practices. And yes, there is the potential for abuse. Remember that Congress passed FISA in 1978 because multiple presidents had abused surveillance authorities to target political opponents, personal enemies, and disfavored ideologies and minority groups.
Yeah, touch on this survey. I just want to get it very clear from you. You would believe that responding to a request for information that this committee has sent out to intelligence agencies about sort of the statistics, you think that on balance, it's better to get that information versus any privacy concerns?
I believe so, and 30 civil liberties organizations have signed a letter saying that, including the major national privacy organizations in this country.
And let me conclude by just saying, all of us here and those intelligence agencies took an oath not to an administration or to a political party or to an agency. It was an oath to the Constitution. And what that means is, even if a program may be effective or not effective or incredibly brilliant, if it violates the Constitution, we just can't execute it unless we change the Constitution. And I just hope people understand that that's what it means when we all take an oath to the Constitution, that is the primary document to which we owe our allegiance. And with that, I yield back.
Come to the floor of the Senate to talk about the Patriot Act. I'm pleased that we have cracked open the door, that we will shed some light on the Patriot Act. I wish the door were wider open, the debate broader and more significant. but we will talk a little bit about the constitutionality today of the Patriot Act. Jefferson said that if we had a government of angels, we wouldn't have to care or be concerned about the power that we give to government. Unfortunately, sometimes we don't have angels in charge of our government. There have been times, even in our history, when government has invaded your household to take things from you. In the 1930s, government came into your household and said, "Give us your gold." Gold was confiscated in this country in 1933. Could there conceivably be a time when government comes into your house and says, "We want your guns"? Well, people say that's absurd. That would never happen. I hope that day never comes. I'm not accusing anybody of being in favor of that, but I'm worried about a government that is sifting through millions of records without asking, are you a suspect? Without asking, are you in league with foreign terrorists? Are you plotting violent overthrow of your government? One of the provisions of the Patriot Act is called the library provision. They can look at the books you check out in the library. Well, people say, well, still a judge has to sign these warrants, but we changed the standard. The standard of the Fourth Amendment was probable cause. They had to argue or at least convince a judge that you were a suspect, that you were doing something wrong. Now the cause or the standard has been changed to relevance. So I don't know if I've been investigated. My Visa bills sometimes have been $5,000. Sometimes we pay for them over the phone, which is a wire transfer. Have I been investigated by my government? I don't know. It's secret. What I want are protection. Just because we believe in procedural protections, just because we believe in the Constitution, doesn't mean that we don't want to capture terrorists, but we just want to have some rules.